Well, we're going to get started here. Good morning, everyone. Thank you for joining. We're excited to bring this group of people together. When you look at where we all sat a month and a half ago, it's our business. A lot of us have had our businesses turned on their sides. And while it felt like it was happening in slow motion some days, when you look at really the span of 90 days and all that's happened, we're all in a similar situation. And while we all have sometimes peer businesses or competing businesses, the folks we've pulled together this morning from Fitzpatrick, Lentz, and Bubba will help us navigate those things that we are all navigating together, and those challenges and the things that are changing. So we're going to get started here without much further ado. I want to start just by introducing Eric Schock, who I've known for over a decade in the executive forum, and he's an attorney at Fitzpatrick, Lentz, and Bubba. Eric, please go ahead.
Hey, thanks, Rob. As Rob mentioned, I'm Eric Schock, and I'm at Fitzpatrick, Lentz, and Bubba. And for the time, we are a law firm with 35 offices in the Lehigh Valley, as our 35 attorneys work from home and try to keep the hair out of our eyes. FLB has been a part of the executive forum for about, I think it's over 15 years now. And as for those of you not in the forum that may be on the call, if you looked at the site, you'd see it's a business support group. And it's been great for FLB over the time, and I encourage anyone to investigate it if you're interested in that type of arrangement. We've benefited from it, and I hope FLB has brought some benefit to the rest of the group. I am in our land development real estate group, which probably is not as useful right now to everyone, because I suspect most people aren't sitting at home saying, hey, I'm going to go right now buy some raw land so I can move my business to that new location. Fortunately, we have some of my colleagues who probably can offer more pertinent and relevant information and advice for the times. So Abby Martin from our commercial business and banking group will go next. And then we would also have Jake Sittman and Stephanie Koenig from our employment law group to talk about that topic. So at this point, I will thank everyone for coming and turn it over to Abby.
Good morning, everybody. As Eric said, I'm Abby Martin, and I am in the corporate business and banking group. My primary practice area is commercial real estate financing transactions. So naturally, my purview today will basically cover the financing options that are available for businesses during this period. So essentially, I'm just going to start out with a general overview of some tips for businesses right now, and then we'll get into the various options available for businesses and small businesses and nonprofits. And then Jake and Steph will follow up with the employment issues. And after my segment, I'll answer some questions that you guys submitted during registration. And then Jake and Steph will do the same thing at the end of their presentations. So first we'll get started with what you can do. And as with everything that's going on right now, the situation is constantly evolving. So there are some suggested practices that were in place last week that are no longer available. And we'll start first with the waivers that you were permitted to request from the state. So if you were deemed a non-essential business, you were permitted a period of time in which you could request a waiver to be able to continue to operate. The deadline for those waivers was last Friday. So we suggest that if you were fortunate enough to receive the waiver, that you continue to follow the governor's advice as to how you should operate during this period. The next just general
repairs are allowed.
Would be if your business has any existing mortgage loans or working capital lines of credit or other sorts of financing vehicles, you should immediately reach out to your banker to request a deferment of your payments for a period of time. that will get you an immediate break on your operating costs for the time being. Most of the local and regional banks are starting with a 90-day deferral of interest and or principal. And then there are also a lot of the banks are leaving it open-ended so that they can grant an additional 60, 90-day period once that 90-day period, the initial 90-day period has lapsed. You can also, if you rent your business location, you could request a deferral of your rent payments for a similar period of time. And that, obviously would be subject to your individual landlord's discretion, but we have seen, a majority of our business clients be able to negotiate something in order to defer their payments for the time being. So the next section that I'm going to get into are the various financing options that are available for small businesses and nonprofits. The majority of these programs are under the SBA, the Small Business Administration. So they follow the same guidelines as far as size is concerned. For the majority of the businesses, they should have less than 500 employees. There are tons of additional guidelines for how you determine size, but that's the standard. So the first program that was rolled out was actually an existing program of the SBA, and that's the EIDL program, which is the Economic Injury Disaster Loan Program. And it was available for regions or areas that were hit by some sort of disaster. So for the most part, historically, they've been used for small businesses who are recovering after a natural disaster of some sort, like a hurricane or otherwise. So that program has been rolled out for businesses who are suffering following the coronavirus epidemic. And the loans available under that program are for up to $2 million. They are available for small businesses as well as nonprofits. And the interest rates are between 2.75 and 3.75%, depending on your business category. The term of those loans the terms are very favorable, and you have 30 years with a corresponding amortization. So it'll be fully amortizing over a 30-year period. You can defer payments for up to a year, subject to the discretion of the SBA. However, there is no loan forgiveness for this particular program. So you are able to use the proceeds of these loans to pay your fixed debts and other operating costs of the business. And your application should be submitted for these loans directly to the SBA. The other program, which was rolled out at the end of last week under the CARES Act, which was recently placed into law, is by far the most popular option for our small business and nonprofit clients. The most beneficial aspect of the PPP loans, as we call them, is that they have the ability to be completely forgiven. So you could be getting free money from the government. So these loans are based on your average monthly payroll costs, and you are eligible for 2.5 months of your average monthly payroll costs up to $10 million. Again, these loans are available to small businesses and nonprofits, subject to the size restrictions of the SBA. The interest rate on these loans is set at 1%, but like I said, there is the ability to have the loans forgiven, at which point you would not owe interest or principal on the loans. If your loan is not forgiven, or if all of your loan is not forgiven, you will have 2 years to pay back the loan at the 1% interest rate. However, once the loan is funded, there is a deferment period of 6 months for principal and interest payments, but interest will continue to accrue during that period. Okay, so your forgiveness is based on how you use the money during the 8-week period following the funding of your loan and whether or not you bring back your employees. So if you have already laid off employees, your forgiveness can be affected by whether or not you bring back your employees onto payroll. And also your forgiveness is based on how you spend the money, and the funds must be spent on specific costs as delegated by the SBA. Okay, so for the PPP loan program, these loans are actually funded through individual lenders, not through the SBA. They're guaranteed by the SBA, which means that hopefully your lender will be willing to give you the money in an expedited manner. But every lender has been approaching the application process completely differently. So for the most part, most lenders are utilizing a standard form application that was distributed widely last week. And then they're also requiring various forms of documentation to basically establish your business and be able to document how you determined your requested loan amount. So basically how you came up with your payroll figure that was used for the 2.5 months of payroll that made up your requested loan amount. So after the application process is complete, the loans will be quickly underwritten by your lender, hopefully, and then the loans will be funded directly by your lender. After the 8-week covered period where you are to spend the loan proceeds, your lender will then be reaching out to you to determine how much of your loan is eligible for forgiveness. And in order to do that, they're going to request a whole new batch of information, including your loan documents, should you have an underlying mortgage obligation, your lease agreements, statements of interest that would be for your mortgage or other debt payments, and utilities and payroll documentation. So I did want to throw in another small regarding a program that's available under the SBA, and that is the EIDL grants, which are for up to $10,000 for pretty much the same sorts of operations that are eligible costs under the EIDL program and the PPP loan program. So this is an expedited grant where you apply again directly to the SBA to get the grant for purposes of making payroll or for paying existing contracts that your business may have entered into prior to the epidemic. So the only catch with this money is if you have received the EIDL grant and then you subsequently are given a PPP loan, the grant will then be refinanced with the PPP loan, and you would have to use the funds for your payroll costs. And that is it for that. Okay, so we had several questions submitted during the registration process, so I'm going to go through those questions now. We had a couple of questions that kind of overlapped, so I'll try to address them all individually, but to the extent that I've already covered them, we'll just kind of gloss over it quickly. The first question was, how does the SBA define a seasonal business? The term is used in the CARES Act to determine total loan amount potential, and we couldn't find an official definition. So essentially, in order to calculate the maximum loan amount available to a seasonal business, you would look at the seasonal employer, the seasonal employer would use the average total monthly payments for payroll for the 12-week period beginning either February 15th, 2019 or March 1st, 2019 and ending June 30th, 2019. And then that average payroll cost would be multiplied by the 2.5-month multiplier to get your maximum loan amount. The next question was, when funded with PPP loans, how do you handle employees that filed for unemployment? So this is a question that, should I not adequately address it because I'm not an employment attorney? Perhaps Jake and Steph can weigh in a little bit later on, but essentially the guidance we've been providing to our clients is that once your employees return to work, then they wouldn't be eligible for the unemployment compensation. We don't necessarily think that they need to pool their applications, but they should notify the unemployment compensation office that their circumstances have changed and that they have returned to work. What payments constitute forgiveness and which do not? So the payments that constitute forgiveness include payroll costs, mortgage interest expense, rent, and covered utilities. I do want to point out that recent guidance has suggested that up to 70 or at least 75% of the loan proceeds should be used for payroll costs, and then up to 25% should be used for the other types of expenses that are permitted under the Act. So in order to maximize your forgiveness under the loan, you should adhere to that ratio. And wondering about all the various tax incentives over and above the PPP portions of the CARES Act. So again, my forte is financing, and so I cannot advise regarding the various tax incentives, but so unfortunately I would need to sort of pass the buck on to your accountants. So if you have any questions regarding those sorts of tax credits, then they would be more suited to address those questions. Lenders are flooded with PPP loan applications. Is priority being given to small for-profit businesses over small nonprofit organizations, as one article indicated? So I checked with some other attorneys in our group, and no one had seen any sort of indication that this is the case. We have submitted numerous applications for local and regional nonprofits. We have not, those applications have not been approved as of today, but we haven't seen any evidence to suggest that they would be underwritten at a different priority level than for regular small businesses. If whomever submitted that question wants to send me the article that they saw, I'd be happy to take a look at it and see, if I can substantiate any of the information in it. What are the specific stipulations to get the loan forgiveness once we receive funds from PPP? So generally, the forgiveness is based on what you do and how you spend the loan funds during the 8 weeks after the loan origination. So the day you get the money, you have 8 weeks to spend it in order to maximize your loan forgiveness. So as I previously mentioned, the forgiveness amount is based on the amount spent on the eligible costs, such as payroll costs, mortgage interest, rent, and utilities during the covered period. The amount spent on those costs is multiplied by the average number of full-time employees during a period in 2019 versus the number of employees that are employed during the covered period. So you're dinged for forgiveness purposes if you do not bring your staff back on to payroll during the covered period. So seasonable employers have a slightly different calculation. Their average number of full-time employees for a reference point is determined from the period of February 15th, 2019 to June 30th, 2019. There are additional reductions should you reduce the salaries of your employees by more than 25% during the covered period, except for employees whose salaries exceed $100,000 a year. The applications for forgiveness will be submitted to the lender and will require meticulous documentation. So we have been advising our clients to open a separate bank account to receive the loan proceeds and to distribute the loan proceeds for those various expenses, so that you can really track the expenses that you're making in order to legitimize your expenses when it comes time to determining your forgiveness. When does the 8-week period begin for the PPP? Again, that period begins the day that you get the money. So, once you know that you're getting the loan, you should start the process of rehiring your employees or bringing them back on, and utilizing the funds to, or applying the funds to eligible expenses. If my bank is not doing the PPP loan, how else can I get qualified? Most banks are requiring that you already bank with them and a previous relationship established. They don't have the capabilities to take new clients. So lots of our clients are experiencing the same issue with their banks. And we've been able to track down some other lenders, whether they're local, regional, or national banks, who are willing to work with non-existing clients. So if you are looking for another lender, please feel free to reach out to us, and we'd be happy to connect you with one of those other lenders who are willing to work with non-existing customers. I laid off most of the staff on March 13th. They were given 2 weeks severance. Are these payments eligible for forgiveness if I list them on my PPP forms? No, because the amounts expended during the 8-week period are the only amounts that are eligible for forgiveness. I want to know about self-employed individuals and gig workers who do not have a regular 9-to-5 job and who may or may not receive 1099s. So recent guidance has suggested that individuals such as gig workers and those who may or may not be paid via a 1099 can submit an application for once applications are open to sole proprietors on Friday. Then PPP files needed to enroll. I'm assuming that the person asking this question wants to know exactly what documentation is required in order to submit an application. As I said, most of the lenders are utilizing a form application that was distributed last week. And there are also, each bank has a different type of, or has a different list of required documentation in order to underwrite the loans. So, but for the most part, we talked about them earlier, you'll need to provide your entity documentation so that they can see how your business is structured and who owns the business. You will also need to provide tax returns and W-2s, 940, 941 statements, and 1099s. Okay, so again, if you'd like to see the application, feel free to reach out to us and we can send you a copy. We can also send you a list of the standard documents that we've sort of compiled by looking at all the various application packages required by the local lenders, so that you can see what you should be pulling together in order to complete and submit an application. Okay, I'm a sole proprietor. I only hire help during events, so they're paid minimum wage. What, or is there anything to help me with lost income during this pandemic? So again, due to the most recent guidance, we believe that you should be eligible to submit an application as a self-employed individual on Friday. Under the CARES Act, there is a provision that permits you to include the sum of payments of any compensation to or income of a sole proprietor or independent contractor that is a wage, commission, income, net earnings from self-employment, or similar compensation that's not more than $100,000 per year prorated over the covered period. So that expansive definition, which includes terms such as net earnings, leads us to believe that even if you're not paid on a 1099, you should be able to submit an application in order to recover that revenue. Okay, what will be the test for returning staffing to normal in June? Is it measured in full-time employees and to annual level, April level, typical June level? So as I've covered previously, in order to maximize your forgiveness under the loan, you want to bring your staff, or as much as your staff as possible, back on as soon as you receive the loan proceeds. At least 75% of the loan proceeds should be used to make payroll during the 8-week covered period, and any unused funds or funds used that don't meet this criteria will be ineligible for forgiveness and will need to be paid back over 2 years at an interest rate of 1%. So basically we're saying when you get the loan, you want to bring your staff back on and pay them. And utilize the loan proceeds to pay them so that you have documentation of how you spent the money during the 8-week period. And that was the last question for me. So I'm going to pass it on to Jake and Steph to cover the various employment matters.
Abby, I'm actually going to just jump in because we got a lot of questions in chat for you, if you don't mind. I think it might make sense for you to just handle it now.
Sure. Can I open it on mine? Yeah. Okay. Whoa.
Do you want me to read them to you, or do you want me to?
I think I've got it. So
Okay.
to start with, would we know before accepting an SBA loan grant if it will be forgiven? So the answer to that is no, because they want to evaluate how you spent the money during the 8-week covered period, which will be from the day you get the loan proceeds to 8 weeks later. When funded with PPP money and you bring back employees, how does that work with employees who filed for unemployment? So I addressed that earlier. Those employees will want to notify the Unemployment Compensation Office that they were brought back on and their circumstances have changed. Sorry. Are we using layoff and furlough interchangeably?
Abby, we can handle that one.
Okay, thank you. If we are denied a PPP loan, can we then apply for an EIDL grant, or is there a deadline for the grant? There is no deadline for the grant that I'm aware of. I believe it's coterminous with the PPP program, which you can apply for up to June 30th. And as I said before, you can actually, you're eligible for both the EIDL grant and the PPP loan. However, if you have utilized the EIDL grant for payroll costs, it will be rolled into your PPP loan and essentially refied that way. Okay. If you applied for the waiver, have you heard how long it has been taking to hear back from the state? So I did reach out to one of our litigators who has been submitting most of the requests for waiver, and he says that there really is no logic for how the waivers have been either granted or denied. So unfortunately, I don't have a good answer to that question. But I do know that they have been granted. And, you know, sometimes it was within a few days and sometimes it was within 10 or so days. So I would just say to keep waiting. What if you do not have employees but are a sole proprietor? So again, I think I addressed that. Sole proprietors are eligible to apply for the PPP loan beginning this Friday. We're not sure if there will be a separate application process, but the current form application does contain information that would be relevant for sole proprietors. So I assume that the application process will be substantially similar. So again, if you want to reach out to us, and we can send you a copy of the form application as well as a list of the documentation that we think that you should gather in order to complete your application. Okay, when bringing back employees who are tipped, must we compensate them in their hourly pay if we are not open yet for operation in order to get forgiveness? So again, the forgiveness guidelines suggest that you cannot reduce someone's compensation by more than 25%, or that dings you from a forgiveness perspective. So I would just keep that in mind when determining how you are paying your employees when they come back. Okay. When 70% of the loan can be used toward wages, does that include paying yourself? So it depends on how you operated before. So if you were paying yourself as an employee, then you would continue to pay yourself as an employee. If you, I'm sorry. So for a sole proprietorship, so again, that will be, you will be submitting your application separately on Friday for if you operate as a sole proprietor. So then the 75% of the proceeds must be used to essentially pay yourself based on the calculation that you use to determine your monthly average payroll costs. Are part-time workers covered under the PPP loan? I think you are going to have to reach out to me after the program to essentially dig down into what you're looking for there, because as far as part-time workers, they are eligible for the calculation of your maximum loan amount, but they do not come into play when calculating forgiveness. The only employees who are considered for forgiveness purposes are full-time employees. Okay. People over $100,000, a portion of their salary can still be used for forgiveness. Correct. If we don't have a waiver but are continuing to work remotely, can that remote work extend outside the home? Can we walk through an empty building for an inspection? We would maintain social distancing and wear PPE, but it's not clear to me whether this is considered acceptably remote work or if it is considered being open, even though our physical office is closed. I will pass that question on to the attorneys who are handling the waiver process and let you know. Went too fast. Okay, the question from Jamie is another employment related question. Originally, the EIDL was listed as having up to $10,000 available, but then got further defined to $1,000 per employee. Would that limit someone to less than 10,000 if they have less than 10 employees? So I'm sorry, I actually don't know how they calculate the 10,000 grant amount, but I'm happy to look into that, Rob, and I will get back to you. Can companies still open and operating but have hardship still be eligible? Yes, all companies are eligible as long as you meet the size requirements. Tim wants to give a shout out to Rick for tax issues. Gotcha. All right, so I have a S Corp, but by myself bio, wait. Okay, so for an S Corp, for that sort of situation, Jeff, you're going to want to file on Friday as a self-employed individual. I'm not sure I understand what you mean by DUA. So it says, can sole proprietors apply for SBA grant loan and apply for DUA? Is that an unemployment acronym? I don't know what that stands for. I'm sorry. Okay, so if you're denied for a PPP loan, do you have the availability to, or the ability to apply for an EIDL grant? So yes, the EIDL grant program is separate from the PPP program and you are eligible for both. However, if you utilize the EIDL grant proceeds to pay payroll, it will be rolled into your subsequent PPP loan. Essentially, it will be refinanced and rolled up under that loan. So I hope that answered your question in full.
Hey, Abby, real quick, we did get clarification on DUA
Okay.
being disaster unemployment insurance.
Okay. So the
Go back to the question.
proprietors apply for
Consultant,
SBA.
you got it.
Go ahead.
No, you got it. You
Apply
got it.
for SBA grant loan and apply for disaster unemployment insurance. I do not know the answer to that, but I will, perhaps Jake and Steph and I can get together to see how those would affect each other and get you an answer. Okay. Can you apply for PPP loan, but hold off on starting the loan until a later date to allow employees to collect unemployment, then start after the stay-at-home? So, you know, as far as the timing of applications and the actual payment of the loan proceeds is concerned, there really is no way that we can provide any sort of guidance as to timing that out. Essentially, you know, in order to maximize your forgiveness, you're going to want to bring your employees back on as soon as you get the loan and start paying them, or keep them on payroll and start paying them. So if you are, you know, unable to do that, then, and you want to sort of delay the application of the loan proceeds, then, you know, you would be running the risk of having the loan not be forgiven. So essentially, if you do delay the application of the loan proceeds to the end of the covered period, then you would have to repay the loan at 1% over 2 years.
Hey, all right, Abby, thank you. We're going to just out of this, for the sake of time, we're going to move on to the next section here, and we've got a log of these questions. We want to get everyone's questions answered as best we can. There may be some follow-up required, but we're going to do our best to stay within the time constraints here and make sure the next group, Jake and Stephanie, have enough time to get through what they want. So Abby, thank you.
Sure.
Hang with us here and listen. And I don't know if Jake or Steph wanted to go next, but if you guys want to take it away, please do. Thank you.
Yeah, sure will. Thanks, Rob. Appreciate everybody allowing us to present today. Shout out to everybody who is participating today on the webinar, with whom we've already spoken extensively about some of these issues. I want to pause just for a second and review sort of where we are today. It's a very fluid situation. So to give you an idea, in the last 2.5 weeks or so, really a compressed time frame, we've had the passage of 2 brand new federal laws that provide both for leave and paid leave under certain circumstances, as well as an expansion of the unemployment compensation eligibility requirements and the payments that someone might be eligible for. And then in the meantime, and again, this is about 2.5, 3 weeks here, we have guidance from various federal and state agencies trying to tell us what these laws mean and how they interact. So for example, we've had additional guidance from the U.S. Department of Labor, the Equal Employment Opportunity Commission, the National Labor Relations Board, OSHA, Occupational Safety and Health Administration, and last but not least, the Pennsylvania Office of Unemployment Compensation. So everybody has been eager to know, what does all this mean and how does it interrelate? And we've been working tirelessly to try to get answers that our clients can actually use to make important decisions so that they can continue to run their business and take advantage of the opportunities that these laws present. I am chair of the group involved in employment law and labor relations matters, and Stephanie is another member of that group. We have been spending a lot of time primarily on the phone and engaging via email with clients over the past 3 weeks to try to address all these questions. And we're not alone. We also have other attorneys at the firm who have been assisting us. Without further ado, I want to start with the first law that we've been really enamored with for the last couple of weeks, and that's the FFCRA. It's the Families First Coronavirus Act. And really there are, several components to this. One is an expanded FMLA leave entitlement. Another is a emergency paid sick leave entitlement. And then the third major employment component of that act was the expansion of unemployment compensation entitlement. So what we'd like to do is really start with the expanded family medical, or it's actually family leave provision. One of the most important things to note about this law is some of you who have a larger workforce know the FMLA because you've had to comply with it, having more than 50 employees. What's a unique feature of this new FMLA expanded requirement is that it applies to small employers, and particularly employers with fewer than 500 employees. So for many small, mid-sized businesses, this is the first time they're going to have to deal with the FMLA at all. There is a limited exception for small businesses, that is businesses with fewer than 50 employees. However, what we will tell you is that based on the guidance that we've received from the Department of Labor, that exception for small employers is exceedingly small. So it, in effect, requires employers who believe they may be or they need an exception under this law, they need to demonstrate that the viability of their company is really threatened by having to provide the leave and paid leave to their employees. So although the statute initially came out and there was wide reporting that there would be an exception for small employers, what we're here to tell you is that that exception is exceedingly small and very limited. There's another another exception, and that's for healthcare providers and emergency responders. We actually received the guidance from the Department of Labor on how broad this exception is last week. And Steph and I were talking about it, and we've been advising our healthcare related clients that this exception is actually broader than you may think. It doesn't only extend to, for example, traditional doctors, direct healthcare providers, hospitals. It can and does apply, pursuant to the guidance, to manufacturers of equipment used in connection with healthcare provided as a result of the COVID-19 pandemic. So what we would say is if you are in a healthcare environment, that you might want to consult with not only the new regulations from the Department of Labor, but give us a call, and you may actually be exempt from having to provide leave or paid leave under these provisions. Steph, I'll turn it over to you, if you don't mind, to talk a little bit more about the FMLA expansion.
Sure, Jake. So this act expanded the traditional FMLA leave to provide for paid and unpaid leave to employees with a minor child who's unable to work or telework due to school or daycare closure related to the COVID-19 pandemic. This leave, again, is limited only to employees who have a need to stay home with their children. And it is their children, and the children must be under 18 years of age. And you do have to provide your employer with notice and with information that it is because their school or daycare is in fact actually closed. Also, one thing that I want to note, and it is in the text on the slide, but it's not only being unable to work, it's also being unable to telework. So if your employee feels that they have a 14-year-old and the 14-year-old can entertain themselves while they telework, this is not something that would apply to that employee. The Act provides for up to 12 weeks of job protected leave for this specific purpose. One thing I do want to point out is that under the new guidance issued by the DOL, which Jake referenced earlier, if an employee has previously used any leave time under the FMLA, that leave time, it's not like they get 12 additional weeks under this expanded FMLA leave. So let's say in the past 12-month look-back period, they've already used 4 weeks. That means under the expanded FMLA, they have 8 weeks left to use. So it's not a 12 additional weeks of FMLA, and I think that's really important here. This also applies to full or part-time employees who were employed for at least 30 days. The 30-day period is based on the date they asked for the leave. So you may have an employee who, when this act went into effect on April 1st, had only been employed for 10 days, but they don't ask for this leave until April 20th. Well, as you can see, they have met that 30-day period then. So it's important to look at the employment component as of the day they request the leave. The key with this, where this really differs from traditional FMLA, is the paid component of it. Because I think, as most people are commonly aware, under traditional FMLA, it is unpaid leave. So I think we should take a moment to look at the paid versus unpaid aspect of this FMLA expansion. So the first 2 weeks or 10 working days are unpaid under this. Now, employees may use and may exhaust other PTO that they may have during this time period, or they may even use the emergency sick time that Jake and I will get to in a few moments under this act for the first 2 weeks of their FMLA. After that, employees are entitled to receive 2/3 of their regular rate of pay, up to a maximum of $200 per day, or $10,000 in the aggregate during the leave. We've been telling people and counseling people, I'm giving you the general rule of the 2/3 of pay and the regular rate of pay and the maximums. But what we've been telling folks is, if your employees do intend to use this, you should reach out to us and we can help you work through what that actual 2/3 of pay is, because there's differences, for example, for part-time workers who are per diem, and so maybe it's not as though they're set to work 20 hours a week or 25 hours or what have you. So that is one thing we've been telling people. If you are in this situation, contact us for more information on what the actual 2/3 of regular rate of pay is. The end of this leave, just like at the end of normal FMLA, the employee must be returned to the same or equivalent position. So that does not differ from the normal FMLA leave, and that is an obligation of the employer if one of your employees takes this act. So I'm going to turn it back to Jake to talk about the paid sick leave that I referenced during the expanded FMLA portion of this.
Thanks, Steph. So there is a section of the FFCRA that requires emergency sick leave pay. And broadly speaking, it requires employers to provide full-time employees with up to 10 days of emergency paid sick leave. Really, it's 80 hours total. This sick leave pay requirement also applies to part-time workers. It's just at a reduced scale, so that, as Steph suggested, if you have part-time employees and you're trying to calculate what their maximum entitlement to sick paid leave is under this law, we can help you out and address that using the formula provided by the Department of Labor. But broadly speaking, it means full-time employees now get 80 hours of paid leave. Again, this paid leave is subject to a maximum or a cap. The per day cap is either $511 a day, if in effect you need sick leave related to your own health, and we'll get to that, or up to $200 a day, similar to the FMLA expansion leave, if you need to take leave to take care of somebody else related to the pandemic. To qualify for this sick paid leave, you have to meet one of the 6 enumerated eligibility requirements. So we put on the screen here, you can see on the slide what they are. I'll quickly go through them. I'll suggest to you that in truth, it's probably conceptually easier to think about it as really 3 reasons. So I will group the first 2 bullet points together. If you have an employee who has to be away from work and cannot telework because they're subject to a quarantine or isolation order, or because a physician has told them to self-quarantine or isolate because of their own health condition, then they are eligible for this paid leave. I'll pause here for a second and tell you that the Department of Labor has told us that the stay-at-home order that's now in effect in Pennsylvania does qualify as a quarantine or isolation order. So that those two, again, conceptually are probably easily viewed together. If a doctor or a government has told you to stay home, that you need to be away from work and work is otherwise requiring you to be at work, then you may qualify for this leave and it must be paid. The next one is, and this is probably the most controversial of the eligibility requirements. If you have an employee, quote, seeking medical treatment due to COVID-19 and they have symptoms, then they are entitled to leave. So what we've had is clients call and say, but Jake or Steph, listen, am I understanding this correctly that someone need only have one of several COVID-19 symptoms and tell us that they are seeking medical treatment to be eligible? And the answer we would tell you is, in essence, yes. And some of our clients have worried about how expansive that leave obligation really could be in practice and in reality, given sort of this eligibility requirement. And we have really commiserated with the clients on that. I will tell you that the Department of Labor has issued guidance that does enable employers to request in writing from employees seeking leave under these eligibility criteria, and mandate that they provide certain requests and information to the employer in writing. To us, as a practical matter, that's not terribly helpful, but we would counsel most employers to request that employees put the leave request in writing and submit some additional information. And again, we can provide you with the types of questions you are permitted to ask the employee under this eligibility criteria. Another criteria, now we're on bullet point 4, is the employee may be eligible for this leave if they have to care for an individual subject to a quarantine or isolation order, or because that individual is subject to direction from a physician to self-quarantine or to isolate. So again, what I'll note here is that the employee need only care for an individual. It doesn't have to be a family member. It doesn't have to be a son or daughter. You might remember from the FMLA Expansion Act discussion we had that in order to be eligible for that type of leave, it had to be a son or daughter. And I'll add that under the FMLA Expansion Act, it has to be a son or daughter that's under 18 years of age. But as you can see here, the sick leave requirement, they don't even need to be related to you, much less be of a certain age or your son or daughter. Another is that you are caring for a child whose school or daycare is closed or unavailable due to the pandemic. So it's really this bullet point, this eligibility criteria, where, as Steph mentioned earlier, ordinarily the FMLA Expansion Act does not require that the first 2 weeks be paid. But if you have someone, an employee who has to care for a child whose school or daycare is closed because of the pandemic and they can't work, then that's a situation where the two laws interact, they interrelate, such that the employee would be eligible for both the FMLA Expansion Act leave of up to 12 weeks and this paid sick leave. Now that should run concurrent, such that the paid sick leave of 80 hours for a full-time employee would go toward the first 2 weeks that would otherwise be unpaid of the expanded FMLA. It's a little bit of a mind-bending exercise to sort of understand this, but the two acts do interrelate. And then if you go to the final bullet point as to this emergency sick leave, there's a part of the statute that talks about eligibility because the employee is experiencing any other substantially similar condition that is similar to the pandemic COVID-19 condition, as specified by the Secretary of Health and Human Services. And Steph, feel free to jump in, but I don't think we've gotten any guidance, despite all the guidance we've gotten. I don't think we've yet seen guidance from the Secretary of Health and Human Services to even what this eligibility criteria means.
No, I haven't seen any.
Yeah, so again, this is a fluid situation. I would say for the time being, and until we get further guidance, there's not a lot to say or to be concerned about, frankly, when it comes to this final eligibility criteria. So again, although there are 6 and you should go through the checklist of the 6 to determine whether or not in a specific circumstance an employee may be eligible for this leave. Really, if you can loop them sort of in your own mind together, the first 2 is someone who's really sick or maybe sick and is told by the government or a physician to stay home, they're going to be eligible. The third one is really an ambiguous one, but if someone says that they may be sick and they are seeking medical treatment, they may be eligible. And then the other 2 really is a situation where the employee is caring for someone, whether it's a child or someone unrelated, who is subject to an isolation order or their daycare or school is closed. We talked just very briefly that employees are eligible. This is again at 2/3 their pay, capped at $511 per day if really in effect it's one of the first couple of eligibility criteria that they meet, or at the lesser amount of $200 per day, subject to aggregate caps. So there are aggregate caps as well. The per day cap is $511 per day in certain instances, but $5,110 in the aggregate. And then in the case where it's a $200 cap, the aggregate cap is $2,000 per day. I'll end this section by commenting on an issue that's come up a couple times, and that has to do with existing PTO policies. So employers often enough have vacation and sick time policies and they vary in terms of how they operate and how much time is afforded and whether they can be used and paid out. What this new law says is that these new leave and pay requirements are in addition to the sick leave policies that employers have. And employers cannot compel employees to use those policy-driven PTO or sick leave or vacation leave entitlements first or in lieu of the paid sick leave under these new laws. So it's something to be cautious about. As we mentioned, there's an unemployment compensation component to the FFCRA. And Steph, I'm going to turn it back over to you to go over some of those new law requirements.
Yeah, so generally speaking, an employee is eligible for unemployment if they've been laid off, furloughed, or have had their hours reduced. Of course, eligibility for unemployment is in Pennsylvania determined by the Pennsylvania Unemployment Compensation Board of Review, or UCBR for short. In response to the COVID-19 crisis, Pennsylvania has temporarily suspended certain UC requirements that they typically have. Specifically, they've gotten rid of the 1-week waiting period, and they've gotten rid of the requirement that those on unemployment compensation have to prove that they are searching for work. These are temporarily suspended, so these will likely come back. I am guessing they will come back as of January 1st, 2021. But we're still waiting for some guidance on that. Before collecting unemployment, an employee must exhaust their paid leave before collecting unemployment compensation benefits. So that's one thing to be aware of. I know there was a question as to layoffs and furloughs, and unemployment is one circumstance where the nomenclature you use, whether that's layoff or furlough, really doesn't impact whether the employee will be eligible for unemployment compensation. The biggest changes to unemployment compensation, however, came from the CARES Act. And that is the second of the 2 acts that were brought about by the federal government. So the CARES Act, what that did is it said individuals who are otherwise eligible for unemployment compensation benefits under state or federal law will get an additional $600 per week in addition to regular unemployment benefits through July 31, 2020. I will tell you that Pennsylvania still has not received guidance from the federal government as to exactly how they are going to distribute this extra $600 per week. So what they are saying is once they get that guidance and once those logistics are figured out, they will backdate that $600 to the week ending April 4th. And again, this extra $600 only applies to individuals who are unemployed due to COVID-19 related issues. So if you happen to become unemployed during this time frame and it has nothing to do with COVID-19, you are not eligible for this extra $600 per week. In addition, the CARES Act has extended the duration of unemployment benefits for an additional 13 weeks. This means that in Pennsylvania, employees will be eligible up to 39 weeks of unemployment. However, that last 13 weeks is at the rate of only $600 per week. There's no requirement that Pennsylvania also kick in additional unemployment for that additional 13 weeks. And again, this only applies to individuals who are unemployed for a reason related to COVID-19. And the third implication of the CARES Act is it does offer a limited unemployment benefit to certain individuals who are otherwise ineligible for unemployment. Examples of these individuals are the self-employed, gig workers, in certain cases, employees who lack sufficient work history to otherwise be eligible for unemployment. Those individuals will get benefits at the rate of $600 per week. Now, another thing I want you to be aware of is, as of yesterday on the Pennsylvania Unemployment Compensation website, Pennsylvania is advising those self-employed, those gig workers not to yet apply for unemployment compensation through this act because, again, they haven't yet received the federal guidance on how they're going to implement this act. So if you are a self-employed individual, it would be my advice to check the Pennsylvania Department of Unemployment Compensation website to get guidance on when would be the appropriate time to apply for this act. But certainly the guidance as of yesterday was it is not yet the time to apply for it. So those are really the key implications of unemployment under the CARES Act. And really, generally, the CARES Act, the biggest part of the employment law aspect of it, again, is the unemployment compensation implications. So I'm going to now kick it back over to Jake just to touch on some additional resources and wrap up.
Yeah, so again, thanks, Steph. If you do look on your screen, our slides, we have a resource page on our website that you can take a look at. It's been updated pretty regularly, and there are some links through our website to get you even more information. As Steph suggested, what we are doing, frankly, is trying to keep abreast of what the federal and state agencies are publishing on an almost daily basis to try and keep abreast on what all these issues are and get further clarity where there is some ambiguity. I want to pause just for a moment, answer some questions, but also give you a sense of sort of the myriad of issues that Steph, I, and others in our employment group have been answering over the past roughly 3 weeks. So, this issue of layoffs has come up, you can imagine, innumerable times. Sometimes the issue is, well, do we lay off and do we furlough? And if we lay off, how many? And if we lay off, what are the unemployment compensation ramifications? Also, if you're large enough, that is, you have more than 100 employees, we've been advising clients about the required notices of layoffs under the WARN Act and helping them prepare the required documentation. Other issues include, well, what do we pay people? Here's what our policies say. Here's what our PTO requirements. Do we have to pay them if we put them on furlough? For example, do we have to pay out PTO or vacation? Do we have to pay them any severance? If we reduce people's hours, how does that affect their exemption status for overtime purposes? Are there ways we can structure it to avoid issues when it comes to exemption status? Other questions relate to benefits, and particularly healthcare benefits, and whether or not there's continued coverage under the healthcare plan during a time of furlough or layoff. We talked about, for the bulk of our time here today, mandatory leave under the new laws. Other issues that have arisen, as you can imagine, are workplace health and safety issues, just practical issues relating to, well, we have an employee who has symptoms and has been tested or will be tested, or we have had employees who are exhibiting some symptoms and believe they've been exposed to someone who is positive. And what do you tell coworkers of that employee? How do you go about letting them know? Do you require them to stay away from work? If so, for how long? And also, we've been dealing with accommodation issues. That is, employees who haven't had any symptoms of COVID-19 and aren't going to be tested, but they're in a compromised immune state or have other health conditions where they feel very uncomfortable coming to work. And how do you address those situations in a humane way, but also in compliance with your legal requirements, but also in a way that enables you to continue operating your business or organization? So we have really encountered a whole myriad of concerns over this time. I want to get back, we've mentioned it a couple times, it came as a result of a question, layoffs and furloughs, and Steph mentioned layoffs and furloughs and how that may or may not affect unemployment, and in general, it does not. In general, furloughs are commonly believed to be periods of time where you are not required to be at work, but that there is a presumption that you will return by a certain date. So that is just a very common perception of what a furlough is. A layoff is less often associated with a presumption of return to work. Where it becomes important for legal purposes or compliance purposes is benefit coverage. What we will tell you is a lot of benefit brokers have told us that insurers and healthcare insurance providers have extended, effectively waived the requirement for at least a month or more that coverage for active employees should only extend through the end of the month in which they remain actively employed. In other words, if you lay off an employee today, that is 8th, traditionally under most plans, and of course you'd have to consult with your broker on the terms of your own plan, but traditionally healthcare coverage would extend through the end of this month, but not into May. Many, if not most, insurers have now permitted employers to continue coverage under those health plans, in my example, through the month of May. Now, one question that we've addressed too with employers as well, how do we pay for that? Do we pay for that? And it's really going to depend on any number of unique circumstances of any individual plan and employer, and we'd ask you to reach out to us and we can help sort of provide you some guidance as to how to address the continued coverage of healthcare benefits for employees in a layoff or furlough situation.
The other thing I might add, just to tag on to what Jake has been talking about furloughs and layoffs and some of the considerations, is a lot of the guidance that we're providing is general guidance during this. Of course, layoffs and furloughs are also impacted by whether you have employment contracts with your employees and whether your employees are part of a collective bargaining agreement. So the best thing to do when you are thinking about the need to do any type of layoff or furlough, even if it's very temporary in nature, is to reach out and make sure that you are adhering to all of the requirements, because this is an area where there's a lot of laws that intersect and there could be a lot of complicating factors.
Thanks, Steph. We had a few questions submitted in advance of today's webinar, so I want to get to the first one listed. And the question was, can you please discuss concerns from essential businesses requiring employees to come into work or the office? We've had a lot of questions about that. In general, if you're an essential business and you have an employee who you require to be at work in order to continue the business, that is the baseline. That is to say, you can continue to require that employee to show up to work. Of course, in instances where you become aware that the employee has requested leave from work because of a health-related issue, whether it's pandemic-related or not, that's where this gets tricky. If it's merely, though, the fear that someone might be exposed to the pandemic as a result of coming to work, but they don't have a very specific or unique health-related condition or issue. And we have received many calls from clients that that's the case. That is to say, people are just concerned, and they don't want to bring a potential virus home to their loved ones, whether they're young children or older family members. And that's certainly a reasonable concern under the circumstances. The issue, though, of course, is that sometimes conflicts with the employer's need for that employee to show up for work. And unless there's a specific health condition issue, we would suggest to you that you should follow your ordinary policies regarding requiring employees to come to work, and follow up with related discipline if necessary, but that you must do so in this environment in an extraordinarily humane and forgiving way. So it may require you to be far more accepting of people's feelings, but then at the end of the day, explain to them what their obligations are in terms of coming to work. Steph, I don't know if you had anything else to add as to that issue.
No, I've had similar issues also, again, dovetailing back to our previous topic of furloughs and layoffs, and similarly with employees who almost want to be furloughed and laid off because of their fear. And again, not a one-size-fits-all answer to this one, unfortunately. So it is something, again, just like Jake recommended, you would treat it a little bit more, not that we're not always humane, but very humane, and probably with a little bit more kindness than just adhering to black and white, excuse me, your black and white rules and policies. There's a lot of middle ground here.
And Steph, one thing I would add too is what we have found at times is that if the employer, when confronted by an apprehensive employee, responds to the employee by explaining all of the measures that they've taken to try and keep people safe and healthy in the workplace, that can have a meaningful effect on the employee's sort of reluctance to come to work. So don't forget about being patient and explaining to the employees all of the steps you have taken, that you have consulted CDC guidance, you are complying with OSHA requirements, you have tried to maintain and communicate policies about social distancing and hand washing and all of the right things, because that can be meaningfully important to employees and sort of improve morale when they come to work. I'm going to move on to another question. Another, and I'm going to summarize here, is essentially if we have employees who work from home but lack adequate childcare, can they reduce the number of hours that they work and still take advantage of the expanded FMLA for the portion of their scheduled work hours that they're not able to meet? And this brings up a really important point that yes, like most regular FMLA leave, this leave can be taken intermittently. Now that can pose a record-keeping challenge for employers, but there's nothing to say that if someone who qualifies under the expanded FMLA leave takes leave, that they have to do so for entire days or for consecutive days or for a consecutive longer length of period of time. So keep in mind that this FMLA leave can be taken intermittently. And so, yeah, they can get paid at the 2/3 wage rate subject to the caps for the remaining time that they have to address childcare rather than come to work.
Yeah, and I've actually had employers ask about the record keeping on this type of intermittent expanded FMLA leave. And what the regulations say is that the employer and the employee have to come to an agreement on how it's going to be used. And several of my clients have been using the typical record keeping that they would use under a normal intermittent FMLA leave to keep records under this circumstance. Again, not perfect, but gives them good guidance and adheres to how they normally do FMLA leave.
And I think that's pretty much the questions we received prior to the webinar. I don't know if there are others we can address here. I'm looking at the chat quickly to see if there are employment-related questions.
As Jake goes through those questions, I just wanted to thank folks for joining us this morning. I think we got through a lot. Just for a moment, again, thanks for joining. And the executive forum of the Lehigh Valley means a lot to the businesses that are a part of it. And we wanted to bring something like this to a larger group of people as a resource. So we're hopeful it was useful. Again, as Jake gets through a couple questions, I just wanted to give him a moment. But thank you everyone for joining. I'll say one or two things, but I appreciate everyone's time this morning.
Rob, I don't see any that are obviously employment related, so I'll turn it back to you.
Sweet. All right, folks. Well, look, I know a lot of folks did submit questions. If you look in the chat, FLB Law provided their website along with info@flblaw.com for additional questions, and I think they'd be willing to answer those. For everyone that did join us, again, thank you. We hope that you found value in this. I've been joking with some folks. We all get a COVID-19 merit badge to wear on our business sashes when this is all through, because I think, you know, this will prove fatal to a lot of businesses, and we want to make sure that those in our group, our friends, our industries are not the ones that end up there. So whatever we can share at this point with each other, that's what we want to do. And that's what the Executive Forum of the Lehigh Valley is about. And I'm just glad to have everybody. Thank you to the folks from FLB who made the time this morning. You can see their contact information up on the screen now. Don't hesitate to reach out to these folks. They are the best in our area and the best in Pennsylvania at what they do. And we're happy to be able to bring this to everybody this morning.
Thanks, Rob.
That's it from everyone. We'll end it here. Please send those emails. Let me just find that one more time. info@flblaw.com, info@flblaw.com. And thank you for everybody. And thank you especially the folks from Fitzpatrick, Lentz, and Bubba, and from the Lehigh Valley Executive Forum for joining us this morning. Thank you very, very much.